welcome to the Robert H. Jackson Courthouse. My name is Mary Loneguth. I am the clerk of the court, and I wish to welcome you all here today. So, here's how we start a court proceeding. Oh yay, oh yay, oh yay. All rise. Good. The United States District Court of New York is now in special session on this Thursday, September 25th, 2025, in observance of Constitution Day. Presiding is the Honorable Lawrence J. Velardo, joined by many of our judges and other dignitaries. Mr. Plessy. Ms. Ferguson.
Today, welcome to the United States District Court for the Western District of New York. My name is Larry Velardo, and I am a judge on the court, and it's my pleasure to welcome you here today for what I think is going to be a fabulous program. You know, the Supreme Court is sometimes criticized for not following precedent, changing precedent, but I think, as the Chief Justice said when he was here a couple months ago, that we all can agree that there are certain times when the court should not follow precedent. And one of those times, I think we all would agree, is when the court decided Brown versus the Board of Education, overruling the precedent in Plessy versus Ferguson. So it's a thrill for me today to be here to hear about Plessy versus Ferguson from Plessy and Ferguson, from descendants of the folks who were the parties in that case. Before I turn the program over to Mike Purley, who's responsible for putting it together, let me introduce some of our dignitaries who are here today. In front of me are two of our magistrate judges in this court, Judge Les Fascio and Judge Jerry McCarthy. Judge Carl Buckeye is seated to my left. And then in the jury box, Judge Jeanette Ogden of our Appellate Division, 4th Department. That's the appellate court. I think I argued there about 150 times. Next to her is someone I refer to as my little sister, Judge Amy Martocci. She's the administrative judge of the 8th Judicial District, and Amy and I were partners together at my law firm and are to this day very, very close, almost like brother and sister. Judge Susan Egan of the Erie County Court. Judge Jahar Pridgen, Chief Judge of the Buffalo City Court. Judge Barbara Johnson Lee of the Buffalo City Court. Next to her, Professor Matt Stylen, Vice Dean at University at Buffalo Law School. Then next to him, Joshua Cohn, a lecturer in law at UB. And then Mike Purley, who's putting this program together. In the next row, Audrey Seeley, an attorney with the U.S. Department of Energy, Office of General Counsel. Douglas Hopkins, the steering committee of the James Otis Lecture Series. Deborah Trapp Thompson, president of the Foundation of Aboda, who's sponsoring this. Mary Starr, a clerk at Hurwitz and Fine. Brian Webb of Aboda. Sarah Rira of Aboda. And then Keith Plessy and Phoebe Ferguson, and we will hear more about them in a few minutes. And finally, Kristan McMahon, the president of the Jackson Center. And I'd like to thank Ms. McMahon and Mr. Purley in particular for putting this program together. They've done an awful lot of work. I can claim no credit at all. I've been so busy I haven't been able to attend a single planning meeting. So if you like the program, give them all the credit. If you don't like it, you can blame me for not being at the meetings. Mr. Purley, I'll turn the program over to you.
Good morning. Not good enough. Good morning.
Good morning.
All right, thank you and welcome to the 11th edition of the James Otis Lecture. Before I continue with welcoming remarks, I want to thank Judge Velardo and his chambers who worked very long and hard, and I threw them any number of curveballs over the last 3 days, but they have hit every one of them out of the park. And in particular, the way everything works so smoothly this morning, I want to recognize the two people that are sitting directly in front of me. Mary Lowenguth, our clerk of court, and Andrew Moeller, who will be the new clerk of court when Mary retires. Give them a round of applause. I want to personally thank today, and I'll thank her again tonight, the person who made the longest journey to get here from Orange County, California, Deborah Trop Thompson, president of our Boda Foundation. She was really, it was really hard to get her here. I said to her when we were at a conference in Banff, I'd like you to come to the James Otis lecture in our fair city of Buffalo on September 25th. She said, send me an email with a date. And she's here. So you don't get here by accident, folks. You earn your way into this room. The James Otis lecture is designed for students who are dedicated to academic excellence. And your dedication to academic excellence was your ticket into this courtroom today. So congratulate yourselves for that and take advantage of an opportunity that does not come to very many people very often. It is my distinct pleasure to introduce Joshua, professor at a lecturer at UB Law School. You've read his bio. But what you don't understand about the people at UB, and I include Vice Dean Stilen in this, is the amount of time and effort they put into the remarks that they're going to present to you today. On Saturday, I think it was, we spent half an hour on a Zoom call because he wanted to get it right for you. So would you please join me in welcoming Joshua Chain.
Hello. It is great to be here. I really do want to give my thanks to Michael, to Matt, to Judge Lardo, for everybody involved in putting on what is, I hope and know, going to be a really wonderful program. I especially want to thank the descendants we have here today from the original litigant and judge in this case, Keith Plessy and Phoebe Ferguson. This is an amazing honor to be able to talk about this very important and unfortunately tragic case in American history. I also wanted to mention, too, that when I was asked to give this talk, it kind of almost was like a moment of like full circle for me in a way. When I was an undergraduate student at Pitt, I was in a history program and I did a history honors thesis on disfranchisement in the American South in the 1890s. And one of the people who kept coming up in a lot of the history I was reading was a man named Albion Turgey. And I read a considerable bit more about him than I probably needed to at the time to do this honors thesis. But I thought he was such a fascinating figure, a committed civil rights attorney, a judge in North Carolina during Reconstruction. So it is kind of just an amazing coincidence and honor to actually be able to talk today about his work as a lawyer. This is the first time I've had an opportunity to really dig into some of the arguments that he made in this case. And I think they have a lot of a kind of modern feel to a lot of the critiques that he had at the time of the statute in Louisiana that was the subject of this case. But also, I think, too, just on a lot of the kind of practices and assumptions of white supremacy in the 1890s, which I think in some respects are still with us today. So, to begin with, I would like to mention that this case, Plessy versus Ferguson, is now seen I think quite rightly, as one of the High Court's most misguided and unjust rulings. It became a kind of cornerstone in the legal edifice of Jim Crow segregation, in particular, the concept of separate but equal. But this case is also known for a very notable dissent by Justice John Harlan, especially his argument, and I'm quoting here, "Our Constitution is colorblind and neither knows nor tolerates classes among citizens." This concept of legal colorblindness would become very influential, but also very contested. In my remarks today, I would like to contextualize the decision in Plessy versus Ferguson as part of a broader effort to reorder and remake white supremacy in the last decades of the 19th century. The Plessy decision was not the cause of these changes, but it lent considerable legal legitimacy to them. And it signaled to both Black and white publics in the South and in the nation as a whole that the federal government's commitment to the cause of emancipation, the full citizenship of African Americans, and a broad interpretation of the post-war amendments had all but come to an end. I will also discuss some of the unusual ways that the ideas about race and color especially factored into the legal strategy of Homer Plessy, the plaintiff, and the lead attorney in this case, Albie and Turgey. Plessy was, by most accounts, discernibly white. Having 1/8 African heritage, he could pass as a white person. His color, in the language of the time, had to be announced by Plessy before he was arrested for entering and refusing to leave a railroad coach car reserved for white people. Albie and Turgey, Homer Plessy's attorney, hoped to show that Louisiana had violated the 13th and 14th Amendments of the Constitution by the very act of assigning people to either a Black or white, a colored or white racial category, and the corresponding railroad cars. But first I want to turn to the historical context. What was going on in the country around this case at the time? Because I think it's very important to understand the issues of white supremacy and racial hierarchy, because they are at the heart of this case. Especially because this case involves what was read by many people, including the author of the majority opinion, as a seemingly neutral concept of equal but separate, or separate but equal. Both framings were used a lot at the time. So, the Plessy decision came about at a time of profound decline in the legal rights for African Americans throughout the South, and it involved protracted campaigns to remove them from full participation in public life. This period was often linked, these movements were linked at the time to the emergence of a kind of radical form of white racism from about the late 1880s onward, premised on an alleged threat posed by African Americans who had never experienced the supposed benign tutelage of slavery. This radicalism, this radical racism emphasized concepts like racial degeneracy, savagery, and criminality. It's something, if you look at newspapers from this time, these kinds of assumptions run throughout them. African American men in particular were seen as posing a sexual threat to white women. A lot of laws created at this time, segregation laws, were premised on this idea that it was for the protection of white women. Perhaps nothing more exemplifies the intensity of this form of white supremacy than the issue of lynching. In the 1890s, late 1880s and 1890s, there was a massive increase in the number of recorded lynchings in the country. According to a database that's maintained by the University of Missouri Kansas City Law School, between 1889 and 1901, there were at least 1,416 African Americans killed in lynchings. The true figure is probably considerably higher than this. A lot of these kinds of incidents were not recorded and committed to memory. These killings often euphemistically attributed to persons unknown, often involved entire white communities. They were frequently very public and highly organized events. Beyond the immediate victim of this kind of violence, these lynchings, as public, popular expressions of white supremacy, terrorized African American communities and always lurked in the background of other efforts to restrict their rights. The 1890s also saw a dramatic reduction in the voting rights for African American men. If you'll recall, women did not have the right to vote at the time. The franchise had been extended after the Civil War to African American men, but during the 1890s especially, this was dramatically reduced. In fact, as the events of the Plessy and Ferguson case were occurring, white political leaders in Louisiana were trying numerous methods to disfranchise substantial portions of the state electorate. A new constitution, adopted in 1898, contained numerous hurdles for potential voters, a whole bunch of different registration requirements, poll tax, a literacy test. All of this effectively removed most African Americans from the electorate by the 1900 election. In addition to this, there were a lot of laws that we commonly think now of exemplifying Jim Crow segregation that developed in the 1890s. This is not to say there had not been previous forms of separation between the races. In fact, after the Civil War, one of the first major acts of refiguring the kind of relations, the spatial relations of African Americans and white people in the United States was the breakup of the plantations, that many African Americans wanted to have their own family farms and not be located so closely to the previous slave owners. But a lot of the separation that it had occurred in the aftermath of the Civil War and after Reconstruction, immediately after Reconstruction, was especially the actions of a lot of private actors. It was not until the late 1880s onward that state legislatures got very, very actively involved in mandating comprehensive segregation laws to reorder public space according to racial categories. These laws varied from state to state, but they came in three large waves, from the late 1880s to about 1893, again from 1897 to 1907, and then a later period from around 1913 to 1950. Interspersed in between these large waves, there was a constant flux of new laws mandating segregation in more and more spaces. Now, the first two waves of this kind of movement focused on areas of public accommodation, including several different forms of common carriers, like trains, streetcars, steamboats. The third wave was mainly focused on segregating areas in new industrial and urban settings, like public toilets and factories. Any place that might be more closely linked to the possibility of heterosexual contact or intimacy between the races, the more likely it was to become subject to these kinds of segregation laws, especially if these places in some ways resembled the home. Thus, hotels, schools, theaters, restaurants were areas of frequent separation, and some of this had predated the 1890s as well. But the laws that came in the 1890s required these areas to be segregated. The means of travel especially became a focal point of a lot of this legislation. Even more so, as a lot of these kinds of areas, trains especially, became more important to Southern society as it recovered from the war, Reconstruction, and began to modernize. Between 1887 and 1891, 9 Southern states enacted railroad segregation laws. Rather than denying service to African American patrons outright, these laws required separate accommodations for each race. They also required, at least in the construction of these statutes, that these separate accommodations be equal. The Separate Car Act, as it's often referred to in Louisiana, which was challenged by Homer Plessy, was a product of this first wave of segregationist lawmaking. The language of separate but equal, or equal but separate, in these statutes was specifically designed to avoid violating the 14th Amendment's Equal Protection Clause. This is a clause at the end of the 14th Amendment that says that state governments are required to apply their laws fairly and equally to all people in similar situations. Treating people differently, if it's to be done at all, must be based on a valid reason. The segregationist carriage laws attempted to sidestep this clause by pointing out that providing the same accommodations, supposedly equal, for members of each race fulfilled the requirements of equal protection. Such laws, it was argued, applied equally to both black, colored, and white. Some of the early statutes in this wave only required that carriers, railroad companies, provide separate accommodations. They did not require them, the laws that is, did not require the railroads to actually do the act of separating, to force people into the different cars. Later laws, including Louisiana's Separate Car Act, did require this kind of racial sorting, and it empowered railroad employees, private actors of a private company, and empowered them to make these kinds of decisions. Now, of course, these railroad cars were rarely equal. The conditions in them were often very much not equal. Some black litigants sued railroads precisely over these unequal conditions, and they occasionally won, kind of forcing conditions to be improved on those separate cars. But the separation itself was a more fundamental problem. It was meant as a way to demean and humiliate African Americans. It was a ritual of racial classification and exclusion from public life, performed in a very public manner, a very public setting. Clearly inferior conditions in cars assigned for black people compounded the indignity of this act of separation. As historian Joel Williamson wrote many decades ago now, like arbitrary disfranchisement, arbitrary relegation to always inferior facilities was a sign of where the power actually lay and where it would likely lie in the future. It was this aspect of the Separate Car Act that Homer Plessy challenged and that his lawyer, Albion Turgi, wanted to focus on in their case. So when the Separate Car Act was enacted in 1890, it immediately provoked an effort to try to get it struck down. The appropriately named Citizens Committee to test the constitutionality of the separate car law raised a bunch of funds for a test case. They hired Turgi as a lawyer. He was a well-known figure at this time. And he was well known for continuing to believe in a lot of the radical republicanism that had animated congressional Reconstruction decades before. He was very well known as a defender of civil rights, and they reached out to him in particular, who was, I believe, living at the time in Western New York when this case started. So Turgi knew from the outset that this would be a very hard case to win. It would be very hard to convince most of the judges to take the fact of white supremacy and the intention of the law into consideration. Much more likely was that the judges would read the law in a very, very formal manner. They would only look at its written text, what it actually said. Because the Separate Car Act required equal but separate accommodations, it appeared on its face to treat both colored and white passengers equally. To try to get the justices to recognize the kind of white supremacist logic of this and the context in which this was occurring, Turgey developed a really unusual legal strategy that focused very much on that act of classification that the railroad employees had to engage in. How were they sorting people by race? How were they sorting people by color? Quoting from Turgey's brief to the court, the gist of our case is the unconstitutionality of the assortment, not the question of equal accommodation. We insist that the state has no right to compel us to ride in a car set apart for a particular race, whatever it is, whether it is good or as another or not. So the best way to approach this Turgey thought was to try to find a plaintiff who might not fit the racial classification scheme that was in this statute. This statute had very binary categories, colored and white. So the idea was to show how this scheme was unworkable and unjust because of its unworkable quality. After a failed first attempt at trying to find a plaintiff for this case, the Citizens Committee selected Homer Plessy. He was a person of 1/8 African heritage or 7/8 European heritage. And in addition to finding somebody who seemed to not quite fit this racial classification scheme, the committee also approached several railroad companies about whether they wanted to participate in this case. A lot of the railroad companies did not like this law for the simple fact that it was expensive for them to make it work. They actually had to provide extra cars. So in June 1892, Homer Plessy purchased a first-class ticket for the East Louisiana Railroad. He boarded the car reserved for white people, and he announced his colored heritage to a conductor who was expecting him. Plessy was arrested and charged with violating the Separate Car Act. Plessy argued that the law violated both the 13th and the 14th Amendments, but Judge John Ferguson ruled that since the railroad only operated within the state, it didn't go beyond state borders, it did not violate some previous rulings that had declared this kind of separation on an interstate railroad to be unconstitutional. Plessy challenged this ruling first to the Louisiana Supreme Court and then later to the U.S. Supreme Court. Turgey's strategy emphasized that no form of racial classification would ultimately be adequate because it would always be arbitrary, because race and color were so difficult to define. But more importantly, it was not simply a matter of trying to find neutral, effective, proper categories to assign people to these different cars. Because just the act itself was an act of racial domination. It was a form of public humiliation. It was a way that white supremacy was being reasserted in this decade. Turgey tried hard to get to the justices in this case to acknowledge this, and in a way he kind of played to what he felt was their racist common sense. Turgey argued that in this context, there was an inherent value to being white or being considered white. And he posed this kind of question, this example, this thought experiment to the justices. I'm quoting here. How much would it be worth to a young man entering upon the practice of law to be regarded as a white man rather than a colored one? According to Turgey, you could think about whiteness almost as a form of property. And if you were assigned to a car that didn't correspond to what your view of what your race, your color was, it would be in effect like taking your property. And the act in question required conductors on the railroad to determine whether if someone was white or colored. If they assigned a white person or a person who could pass as white to a colored car, they were, in Turgey's argument here, they were harming a person's reputation. They were damaging a person's property. And they were doing so in a very arbitrary way. And Turgey emphasized the arbitrary nature of these categories through the plaintiff Homer Plessy, who did not seem to really fit in these categories. It highlighted how arbitrary these kind of racial classifications were. Turgey went on and he listed over 20, I believe, different state laws from across the US that tried to define racial categories. And the effect was to show how much it varied from place to place, how unstable this was. And he criticized the Separate Car Act because it provided no guide for railroad conductors on how to do this. So in addition to the Fourth Amendment requiring equal protection, it has another clause in it as well that prohibits a state government from depriving any person of life, liberty, or property without the due process of law. This is often referred to as the Due Process Clause of the amendment. The Separate Car Act's requirement for color classification violated this due process requirement because it deprived someone, potentially, of a property interest in whiteness. This also meant, conversely, that there was a reputational quality of inferiority to being labeled colored. Now, the majority opinion writer in this case, Justice Henry Brown, he rejected this argument. He refused to directly acknowledge that the intention of the act was to legally entrench racial subordination and white supremacy. He argued, and I'm quoting here, the underlying fallacy of the plaintiff's argument is to consist in the assumption that the enforced separation of the two races stamps the colored race with a badge of inferiority. If this be so, it's not by reason of anything found in the act, but solely because the colored race chooses to put that construction on it. In effect, he was blaming the colored race for their own, this label of inferiority. He was not acknowledging that the act itself was what was producing this. Justice John Harlan, in dissent, excoriated Justice Brown for his willful blindness to the realities of racial subordination, the real reason why this act was created. Quoting Harlan, "Everyone knows that the statute in question," emphasis in original, "everyone knows that the statute in question has its origin in the purpose not so much to exclude white persons from railroad cars occupied by blacks, but to exclude colored people from coaches occupied or assigned to white persons." Justice Harlan's famous quote that our Constitution is colorblind and neither knows nor tolerates classes among its citizens was also a part of his criticism of Brown's opinion. But it was not meant in a way to ignore race, to not see it, to not acknowledge racial hierarchy, but to point to the ways that these aspects of our society worked through a seemingly neutral rule that helped create and endorse this kind of white supremacy, this kind of segregation. So, I want to wrap up by relating an account by a young man who was traveling in one of these separate cars, not in Louisiana, but a very similar one in Mississippi nearby. He related his account of this trip that he was taking in Mississippi to the great newspaper, the Chicago Defender. And he said that this separate colored car was universally filthy and uncomfortable, that it was a place of indignity and disgrace and shame. I'm quoting here. The car was a disorderly jumble of various different people, of cargo, and of animals. It was used by families, but it was also used by various workmen with all their assorted equipment. A deputy sheriff was there escorting 6 shackled black men headed to the state prison farm. There were also chickens and other livestock crowded into this car, in addition to large amounts of baggage and boxes. The intended degradation was obvious. The intended humiliation was obvious. In his words, quote, "No grander lie was ever enacted into law than that declares separate but equal accommodations. There will never be equal accommodations for the race. Separation presupposes and invites inequalities." Thank you.
Okay. So for those of you who don't know me, my name is Kristan McMahon, and I have the privilege of serving as the president of the Robert H. Jackson Center. And it's quite a privilege to be in conversation with Keith and Phoebe. I consider us old friends at this point. So let me give you a brief introduction. Phoebe Ferguson is a native New Orleans and the great-great-granddaughter of Judge John Howard Ferguson. In addition to her work with the initiative of Plessy and Ferguson, she is the founder, producer, and director of Bayou and Me Productions. The New Orleans-based studio collaborates with community members and local organizations to make films on pressing social issues, including the need for equitable, community-based public schools. Phoebe studied at Art Center College of Design, New York University, and at Tulane. Keith Plessy is a native New Orleans as well, from the 7th Ward, and a first cousin 3 times removed from Homer Plessy. So see if I can do this math, great-grandson of Homer's cousin.
Correct.
Thank you, okay. Plessy has worked in the hospitality industry at the New Orleans Marriott for more than 40 years, since his graduation from the New Orleans Center for Creative Arts in 1976. And 3 years after graduating from the New Orleans Center for Creative Arts, he designed and painted the images of more than 100 famous African Americans at his former elementary school, the historic Black institution, the Lena C. Jones Elementary, as a thank you to his early childhood teachers. Something for you students to think about. How would you thank your teachers? In 1997, Plessy met one of his heroes and a leader of the modern civil rights movement, Rosa Parks. And Rosa said to him, "Your name is Plessy. You got work to do." The Plessy and Ferguson initiative was founded in 2009 by these two descendants. And as you've just heard from Professor Cohn, the landmark Plessy v. Ferguson United States Supreme Court case, which upheld the constitutionality of racial segregation in the United States. Plessy and Ferguson works and focuses on civil rights history, memorialization, and transitional justice. Keith and Phoebe, I suspect this is the first question that you always get. There's perhaps not a natural intersection between your lives prior to your meeting. So how did you first meet each other?
May I go first? Okay. I'd like to give credit to a famous author named Keith Weldon Medley, who may he rest in peace, passed away recently. His book, We as Free Men, was written when Phoebe met him in 2001 or so, 3? And I met him in 1996. But eventually, he knew what he had in his book after 25 years of research, because he researched the case, the Citizens Committee, and everything that happened in New Orleans. So he knew what he had when he had Phoebe and I, so he put us together at his book signing. Mm-hmm. And when we met, I guess the first thing Phoebe did was apologize for history. And it was a shock to me, and what I did automatically out of my heart was say it's no longer Plessy versus Ferguson, it's Plessy and Ferguson. And we became friends.
This photograph captured the moment that we actually met. I didn't know I was going to meet Keith. Keith Medley had set it up, and he just said, "I'd like you to meet someone." And I walked in, and Keith came over and said, "Hi, I'm Keith Plessy." I'm Phoebe Ferguson.
And then, so Keith, you uttered the famous words, Plessy and Ferguson. Yes. How did the foundation come to be? How did this initiative start?
Well, we formed the organization in 2009 in July on the 9th of July. That was the day that the 14th Amendment was signed, was ratified, I think. And we were not aware of that either.
It's funny that kismet sometimes happen like that.
Yes, but that first year we marked the spot in February on Keith Weldon Medley's birthday with a marker that we have honoring Plessy versus Ferguson. We were not even an organization yet, but we announced that we were going to form the organization on that day.
That's great. Phoebe, anything you want to add to that story?
I guess, so Keith Medley was the inspiration for putting up historic markers that recognize African-American history, achievements, and resilience and resistance. And he wrote this marker and taught us about the importance of a public, permanent memorialization as a tool for educating the public. And so this was, in fact, the first marker. And this picture, it just shows you every single day busloads of students and tourists stop at these markers, and you'll see some more of them. And it just really are impacted by the history. You know, we did not know this was going to happen, but it does every day. So it's really wonderful.
And just a comment about the author.
Yeah.
He was the brainchild of the marker system that we began to put up, but he was also the author of the first 4 markers that went up.
How many markers are there now?
Right now, 8.
I think there are 8.
8.
Nice, okay.
Yes.
Yeah. This is just an image of the Citizens Committee who strategized the arrest of Homer Plessy, and the image is in a newspaper, a Black-owned newspaper called the Tribune. And, you know, we don't have a lot of images. There's no image of Homer Plessy, for instance, but this just gives you some sense. There were 18 committee members that worked to strategize this case, not just, you know, Homer Plessy.
Absolutely.
No offense, Keith.
Well, there was also, you'll never see their pictures, but there were women involved in that movement. And as our history does record in a kind of chauvinistic way, we don't mention the women, but there were women behind a lot of the movement, the early movement in the 1800s.
I think it continues to come to light in history that the movements are always broader than just the public faces, and just the legions of people behind them that really take to move something like that forward. Absolutely. Of the work that the Plessy and Ferguson initiative does, what are some of the highlights that stand out to you both?
Well, I would just say that I'm going to show you a few pictures here because this is the second marker that we did with Keith Medley, and it was a super important piece of history to acknowledge. And I'm going to let Keith tell you a little bit more about it. This image is a photo of the three girls who integrated one of the 2 schools in 1960, the same year that Ruby Bridges integrated another school. And there had been very little acknowledgement about these 3. And with them are the United States Marshals that escorted them into school every day.
Okay, to put it all in perspective, just like Plessy versus Ferguson, Dred Scott versus Sanford, Brown versus Board of Education et al., there was Earl Benjamin Bush versus Orleans Parish Public Schools. And that case allowed the 3 women that are now women, but they were 6-year-old girls at the time, allowed 3 girls to integrate McDonough 19, and there was another little girl named Ruby Bridges who integrated William France School, which was in the upper and lower 9th wards of New Orleans. And the story was broken up because you will never hear the names much but now you will, of Leona Tate, Tessie Prevost, and Gail Etienne. And may Tessie Prevost rest in peace. She recently passed away. But this particular marker allowed the 3 women who had been denied the right to be recognized for that date to honor McDonough 19 with that marker. That was our second marker with Keith Weldon Medley as the author of the marker. And it did state about all 4 girls and the case. So it brought to light.
And we unveiled it on the 50th anniversary
Exactly.
of the day they integrated schools.
That's great.
And they had, like he said, they had not been acknowledged. And this picture shows you the impact that publicly acknowledging what they went through and who they are to have endured so much and who have done so silently. So it was an incredibly moving ceremony. And this picture shows you the 3 women with the 3 U.S. Marshals that escorted them into their schools every day for a year.
Wow.
So this one, we really feel.
Absolutely. I appreciate you diving into history to bring those hidden stories, those untold stories to light. I will also challenge our students to think that through in their lives as well, and as they move forward, that where are those hidden stories that crucially add this context, and as you said, the importance of being seen and heard and finally acknowledged as being a part of this. I can only imagine how deeply they were touched and how moved the crowd would have been as well just to see that. Yeah. Absolutely. Okay. I am mindful that there was also a very significant thing that happened in New Orleans regarding Plessy much more recently. And I know you have a video about that as well. I think we have some time to show the video. So if you would be so kind.
So,
of my Orleans district attorney predecessors prosecuted Homer Plessy's brave defiance of the Louisiana Separate Car Act of 1890. Just one of many Jim Crow laws passed by the Louisiana legislature to codify white supremacy and racial segregation after the Civil War. Homer Plessy died convicted of this crime, but the legacy of Jim Crow laws lived on for generations. Lived on, that is, until a steady stream of civil disobedience by heroes standing on the shoulders of leaders like Homer Plessy risked their lives, causing so much good trouble that elected officials were forced to act. But the legacy of separate but equal still casts a shadow on all of our lives today. That shadow is clearly visible in the gross inequalities we see across this city and across this state, and I say across this country. It was important that the office that prosecuted Homer Plessy be the office to ask for his name to be pardoned. Because we all know that while Homer Plessy's actions at that time made him guilty of a crime under the law, it was really the law that was the crime. My predecessor should not have prosecuted Homer Plessy. Just because a law can be enforced or a person can be prosecuted does not mean that they should be. Slavery was lawful for 250 years in this country. The late Archbishop Desmond Tutu said, "True reconciliation exposes the awfulness, the abuse, the hurt, the truth. It is a risky undertaking, but in the end it is worthwhile. Because in the end, only an honest confrontation with reality can bring real healing. And although our great country has slow-walked its reckoning, the office of the DA will not. America has never had a process of truth and reconciliation, an honest confrontation with the reality of its oppressive past. And we see the direct consequences of this failure to have an honest conversation so boldly in the criminal legal system, most notably with the grossly disproportionate criminalization and incarceration of African Americans. The Orleans Parish District Attorney's Office is now working openly and transparently towards confronting those dire consequences. But while we seek to correct the sins of the past, we must acknowledge my predecessor's roles in committing these sins, if for no other reason than to build the public's trust in our legal system. We must reckon with our past. We must confront, we must acknowledge, and we must humbly ask for forgiveness for the role our legal institutions have played in the apartheid that the people of this country have endured. Let me be clear. Homer Plessy was no criminal. He was then and he is now a hero. And we will do our part to ensure that history reflects just that. Homer Plessy, Louis Martinet, Albion Toujé, and the Citizens Committee belong to a long line of heroic civil disobedience that Dr. King traced all the way back to the early Christians defying unjust Roman laws. The state of Louisiana prosecuted Homer Plessy to make a point of upholding a racist law. And just as these trains are weighing in and hissing the same way they did when he boarded that train, today we make a very, very different point. We now ask our governor, Governor John Bell Edwards, to pardon Homer Plessy from the stain of immorality on our state's history. So let me welcome our friend of New Orleans, friend of justice, our governor, John Bell Edwards.
So that is the governor holding up the official pardon after the ceremony, and the ceremony was so powerful. The speakers were amazing, but I thought you might appreciate what our district attorney had to say here.
And that happened on January the 5th, 2022. And if you look at the lady in the purple top, that is John Marshall Harlan's great-great-granddaughter. She played the cello in the tune to Lift Every Voice and Sing before the ceremony.
That's amazing.
So we had the Harlan family with us.
That's amazing.
And they also signed the documents to the pardon board, so we had lots of ancestors signing it. And obviously we had a unanimous decision by the pardon board to move forward with this.
And not mentioning her name, Kate Dillingham is John Marshall Harlan's great-great-granddaughter, professional cellist.
I think we have time for one question from a student, and I wonder if Isaiah Firestone is with us. And would you be so kind as to come up and read your question, please?
Thank you. So you both have an experience in art, especially as it relates to social justice. And as we were looking through your website, we saw a lot about your partnership with the New Orleans Center for Creative Arts and a lot of art in there. Could you just describe a specific project that involved the arts that you feel like had a big impact that really reflected your organization's mission? And if you have any future projects coming up you'd like to share?
Well, I'll speak first, and then I'll hand it to you, Phoebe. Being a graduate, alumni of the New Orleans Center for Creative Art, it inspired me to go on the journey that I did, going back to my elementary school and paying homage to my teachers by putting those portraits on the wall. And that was just one thing, that was a seed that was planted a long time before we met. And when we finally circled around to that spot, because it was in a different spot when New Orleans Center for Creative Art was located around Tulane University when I attended in 1976. I'm a graduate of that class. But when we circled around and we began talking about putting a marker there on NOCA's property, it was a no-brainer. And when we put that marker up, first of all, that set the history in motion for this to happen. Because when we circled back around to when we were going to do the pardon, the posthumous pardon for Homer Plessy, it was also a no-brainer to do it in the spot where he was arrested. And he was actually thrown off the train in the spot where that marker is. And NOCA, New Orleans Center for Creative Art, was the train station before it was turned into, eventually,
Keith,
an art conservatory.
not to interrupt you too much, but would you tell the audience about the first theatrical event at NOCA?
Yes. Well, to tie it into the arts, like you're saying, Phoebe, there was a record of artistic collaborations with NOCA in our events, which we have an event every year. June 7th is considered Homer Plessy Day, declared by the then governor in 2005, before Katrina hit. But the first Plessy Day we had was in honor of dance. So we took a dance group for NOCA, and they performed what they called the appeal. And it was a dance choreographed. It was set up to choreographed to coincide with the appeal. And they were talking about the Citizens Committee and how they stood up to the Louisiana Separate Car Law. Second celebration we had at NOCA was drama. And it was a play called Separate. And each student portrayed themselves and how segregation affects them in their lives today. So following after that, I think we went to authors, and we had books. A.P. Turo Sr., we dealt with his book. That's the gentleman that actually filed the case of Benjamin Bush versus Orleans Parish Public Schools. And by the way, his son, A.P. Turo Jr., is on our board. So tying in with art, definitely. We thought that would be a good collaboration, and it worked.
It was actually our original mission in
Yes.
2009, which was to teach this history through the arts. We have evolved, a lot in 15 years, but thank you for that question.
Thank you, guys.
All right.
All right, unfortunately, we also have to wrap this up, but I want to ask each of you, what piece of advice would you leave for the students to take with them today?
I'll start with what you said. Find a way to give back. If there's a way that you can thank any of your teachers previously who helped you, go back, visit the school that you formerly attended. See who's attending that school. Help the teachers with whatever you can with your skills. And I suppose since you are sitting in this courtroom and all these distinguished judges, lawyers, everybody's here and you're looking right at them, I'm thinking you are the future of this courtroom. Many of you may sit in those seats. Many of you may occupy some lawyer's office. And I would say, apply what you've learned for future generations.
I would urge you to talk to your parents and your grandparents and your other relatives and ask them about their history growing up as it relates to race, segregation, whatever, not whatever, but, and what, because many people do not speak about their legacy, right? And they don't tell their children. So it's very important for you to understand who you are by understanding their history, your ancestors' history. It is a key to who you will become in the future by knowing your past. And then I would also urge you to do your part in uncovering stories and preserving Black history in your communities to help educate the public and yourselves, and to keep a lasting memory of what has happened in the past.
Well, and thank you both for being part of our educational legacy. Would you please give Keith and Phoebe a round of applause?
So Dr. King said that the arc of the moral universe bends toward justice. I think one of the lessons today is that that arc doesn't bend in a linear fashion. Sometimes it's 2 steps forward and 1 step back. But the fact that Plessy versus Ferguson is now Plessy and Ferguson tells us that the arc is bending in the right direction. And let me say one last thing, and that is that there are some people today who think that to promote American exceptionalism, we need to forget about slavery, we need to forget about Jim Crow, we need to sweep those things under the carpet. I think just the opposite. I think we should embrace our past and trumpet our past and talk about how the arc has moved toward justice in the United States. I think that is what makes America exceptional, that we try to improve ourselves and to move in the right direction. So every day as a judge, I get to try to move that arc toward justice, and I try very hard. But I hope all of you will too. I hope all of you will do what you can to do what Martin Luther King said, and that is move that arc toward justice. Perhaps not in a direct way, perhaps not as fast as we'd like it to happen, but moving in the right direction anyway. Court is adjourned. Thank you all very much.